Members of the jury, this action is won by an administratrix duly appointed, as you saw on the opening of the trial, by the surrogates court, representing the next of kin of this family, consisting of the wife and the baby, who have been present in court here, and it is to recover damages against the defendant for the pecuniary loss, that is, the actual money damages which were sustained by reason of the death of the deceased. You understand at the outset it is purely a statutory action. At common law there was no right to recover at all, and all that can be recovered in this kind of an action by the next of kin is the pecuniary or the actual money damages which they have sustained. There can be no recovery whatever for any pain and suffering of the deceased, and there can be no recovery of any kind or character for mental anguish of those that survive. That is a preliminary statement which I have referred to in relation to the damages. I call your attention to it first because the action is based upon that theory, and no inference is to be taken by you because of such statement that the court desires to indicate to your mind money damages must flow. It is my duty to guide you with respect to the extent of the damages these people would be entitled to, provided your verdict be in favor of the plaintiff. Of course, there are legal responsibilities with which you must be familiar before you can judge between these litigants, the responsibilities which they owe to each other at the time we find them in this garage on May 6, 1991 at Amsterdam Avenue. You will recall that counsel for the defendant at the end of the plaintiff's case, and again at the end of the defendant's case, moved this court for a dismissal of these proceedings, and the court denied both of those motions. The denial of those motions, ladies and gentlemen, is not to be taken by you as indicating an opinion upon the part of the court as to the merits of this controversy. It only means that the court has decided in the exercise of its function that questions of fact have often arisen which must be placed in your hands for examination and determination. You realize it is the function of the court to give you the law as it arises under the particular facts presented during the course of the trial. And correspondingly, it is your duty to accept the law from the court as it makes it applicable. That, of course, is based on very logical reasoning, because if, at the termination of my charge, these gentlemen representing their respective clients are not in accord with the law that I make applicable to this situation, they have a perfect right to note an exception upon the record, and that record protects them against my errors. For there is a higher tribunal than this to pass on my errors, if any be committed. But if jurymen go out to a jury room and start to make law of their own outside of the courtroom, as distinguished from what the court says the law is, you can readily see that nobody has an opportunity of taking exception to that. So therefore, with that particular rule in mind, that you are to take the law as the court lays it down, I call your attention with the same force and effect to the fact that you, and you alone, are the sole judges of the issues of facts, the credibility of the witnesses, and the truth of the story as related by them. Your determination upon questions of fact is to be controlled by your own recollection as to what the evidence was that was presented during the course of the trial. It is within the province of counsel and their right and their duty to refer to the facts in their summation, to draw reasonable inferences as to what these facts may indicate to them. However, you are not bound by their statement of facts, nor are you bound by the inferences that they draw from the particular facts that have been presented. You being the sole judges of the truth and the credibility of the witnesses, it is your duty to rely upon your own recollection of the facts and the reasonable deductions that you can make from those facts. This action, ladies and gentlemen, is predicated on what is known in law as negligence. Negligence, in its simplicity, means the failure or the omission to use reasonable care in the performance of a duty which one owes to the other, and which is found to be the proximate cause of the injury complained of. It is elementary, of course, and understandable by you that the principal is responsibility for his agent's acts. So if this accident happened because of the failure upon the part of an employee of this defendant company to use reasonable care in the performance of a duty in which he was engaged, that would be what is described as negligence, and the superior stands responsible for the particular acts. So we go now to see whether or not on the facts there has been a violation on the part of this defendant through its agent of the duty to use reasonable care in the management, operation, and control of this elevator at this particular time.